Rule 74, Summary Settlement of Estate. Rule 74 provides a simplified and speedy procedure for settling the estate of a deceased person without the need for ordinary administration proceedings, when the requirements of the rule are present. It provides two principal modes of summary settlement: 1. Extrajudicial settlement by agreement among the heirs under Section 1, and 2. Summary judicial settlement of a small estate under Section 2. Section 1. Extrajudicial settlement by agreement between heirs. If the decedent left no will and no debts and the heirs are all of age, or the minors are represented by their judicial or legal representatives duly authorized for the purpose, the parties may, without securing letters of administration, divide the estate among themselves as they see fit by means of a public instrument filed in the office of the Register of Deeds, and should they disagree, they may do so in an ordinary action of partition. If there is only one heir, he may adjudicate to himself the entire estate by means of an affidavit filed in the office of the Register of Deeds. The parties to an extrajudicial settlement, whether by public instrument or by stipulation in a pending action for partition, or the sole heir who adjudicates the entire estate to himself by means of an affidavit, shall file, simultaneously with and as a condition precedent to the filing of the public instrument, or stipulation in the action for partition, or of the affidavit in the office of the Register of Deeds, a bond with the said Register of Deeds, in an amount equivalent to the value of the personal property involved as certified to under oath by the parties concerned, and conditioned upon the payment of any just claim that may be filed under Section 4 of this rule. It shall be presumed that the decedent left no debts if no creditor files a petition for letters of administration within 2 years after the death of the decedent. The fact of the extrajudicial settlement or administration shall be published in a newspaper of general circulation in the manner provided in the next succeeding section, but no extrajudicial settlement shall be binding upon any person who has not participated therein or had no notice thereof. Explanation. Section 1 allows the heirs to settle the estate without securing letters of administration when the decedent left no will and no debts, and the heirs are all of legal age, or the minors are represented by judicial or legal representatives duly authorized for the purpose. The heirs may divide the estate among themselves by means of a public instrument filed with the Register of Deeds. If the heirs disagree, they may resort to an ordinary action for partition. When there is only one heir, that heir may adjudicate the entire estate to himself or herself through an affidavit of self-adjudication filed with the Register of Deeds. The parties to the extrajudicial settlement, whether through a public instrument or a stipulation in a pending action for partition, or the sole heir executing an affidavit of self-adjudication, must file simultaneously with and as a condition precedent to the filing of the instrument, stipulation, or affidavit, a bond with the Register of Deeds. The bond must be equivalent to the value of the personal property involved, as certified under oath by the parties, and is conditioned upon the payment of any just claim that may be filed under Section 4.
The decedent is presumed to have left no debts if no creditor files a petition for letters of administration within 2 years from the decedent's death.
The fact of the extrajudicial settlement or administration must also be published in a newspaper of general circulation in accordance with the succeeding section. However, publication does not make the settlement binding upon everyone.
The rule expressly provides that no extrajudicial settlement shall be binding upon any person who did not participate in it or had no notice thereof.
Thus, an omitted heir who neither participated in nor had notice of the settlement is not bound merely because the settlement was published. Section 2. Summary Settlement of Estate of Small Value. Whenever the gross value of the estate of a deceased person, whether he died testate or intestate, does not exceed 10,000 pesos, and that fact is made to appear to the court of first instance having jurisdiction of the estate by the petition of an interested person, and upon hearing, which shall be held not less than 1 month nor more than 3 months from the date of the last publication of a notice, which shall be published once a week for 3 consecutive weeks in a newspaper of general circulation in the province, and after such other notice to interested persons as the court may direct, the court may proceed summarily, without the appointment of an executor or administrator, and without delay, to grant, if proper, allowance of the will, if any there be, to determine who are the persons legally entitled to participate in the estate, and to apportion and divide it among them after the payment of such debts of the estate as the court shall then find to be due, and such persons, in their own right, if they are of lawful age and legal capacity, or by their guardians or trustees legally appointed and qualified, if otherwise, shall thereupon be entitled to receive and enter into the possession of the portions of the estate so awarded to them respectively. The court shall make such order as may be just respecting the costs of the proceedings, and all orders and judgments made or rendered in the course thereof shall be recorded in the office of the clerk, and the order of partition or award, if it involves real estate, shall be recorded in the proper register's office. Section 2 provides a summary judicial procedure for settling a small estate. It applies whether the decedent died testate or intestate, provided that the gross value of the estate does not exceed the amount stated in the rule, subject to subsequent legislation affecting the applicable jurisdictional threshold. An interested person may petition the proper court, and after the required hearing and publication, the court may proceed summarily without appointing an executor or administrator. The court may allow the will, if any, determine the persons legally entitled to participate in the estate, pay the debts found to be due, and apportion and distribute the estate among the proper heirs or beneficiaries.
The notice must be published once a week for 3 consecutive weeks, and the hearing must be held not less than 1 month nor more than 3 months from the date of the last publication.
After the court determines the proper distributes and settles the debts, they may receive possession of the portions awarded to them. The court may also issue appropriate orders concerning costs, and judgments involving real property must be recorded in the proper register of deeds. Bar question: a decedent left a will and an estate falling within the applicable statutory threshold for summary settlement of a small estate. An interested person filed a petition under Section 2 of Rule 74. Another heir argues that Rule 74 cannot apply because the decedent died testate. Is the argument correct? Answer: no. Section 2 expressly applies to the estate of a deceased person whether he died testate or intestate. Upon petition by an interested person and compliance with the publication and hearing requirements, the court may proceed summarily without appointing an executor or administrator. The court may allow the will, determine the persons legally entitled to participate, pay the debts found to be due, and distribute the estate.
Therefore, the existence of a will does not prevent the use of the summary settlement procedure under Section 2, provided the statutory requirements are satisfied.
Section 3. Bond to be filed by distributes. The court, before allowing a partition in accordance with the provisions of the preceding section, may require the distributes, if property other than real is to be distributed, to file a bond in an amount to be fixed by court, conditioned for the payment of any just claim which may be filed under the next succeeding section.
Section 3 applies to a summary judicial settlement under Section 2.
Before allowing partition, the court may require the distributes to file a bond when property other than real property is to be distributed. Unlike the bond under Section 1, which is expressly required as a condition precedent and is based on the value of the personal property, the bond under Section 3 is discretionary, because the rule uses the word may, and the amount is fixed by the court. The bond is conditioned upon payment of just claims that may subsequently be filed under Section 4. Bar question: in a summary judicial settlement under Section 2, the court distributes personal property to the heirs. One heir argues that the court must require a bond equivalent to the value of the personal property. Is the heir correct? Answer: no. Under Section 3 of Rule 74, when property other than real property is to be distributed, the court may require the distributes to file a bond in an amount fixed by the court. The use of the word may makes the requirement discretionary. This differs from Section 1, where the bond is expressly required as a condition precedent and is equivalent to the value of the personal property involved.
Therefore, under Section 3, the court has discretion to require a bond and to determine its amount.
Section 4. Liability of distributes and estate. If it shall appear at any time within 2 years after the settlement and distribution of an estate in accordance with the provisions of either of the first two sections of this rule, that an heir or other person has been unduly deprived of his lawful participation in the estate, such heir or such other person may compel the settlement of the estate in the courts in the manner hereinafter provided for the purpose of satisfying such lawful participation. And if within the same time of 2 years, it shall appear that there are debts outstanding against the estate which have not been paid, or that an heir or other person has been unduly deprived of his lawful participation payable in money, the court having jurisdiction of the estate may, by order for that purpose, after hearing, settle the amount of such debts or lawful participation and order how much and in what manner each distributee shall contribute in the payment thereof, and may issue execution, if circumstances require, against the bond provided in the preceding section or against the real estate belonging to the deceased, or both. Such bond and such real estate shall remain charged with a liability to creditors, heirs, or other persons for the full period of 2 years after such distribution, notwithstanding any transfers of real estate that may have been made. Section 4 provides a 2-year period of protection after settlement and distribution. If, within 2 years, it appears that an heir or other person has been unduly deprived of his lawful participation in the estate, that person may compel settlement of the estate in court for the purpose of satisfying his lawful participation. Likewise, if there are unpaid debts or an heir or other person has been deprived of lawful participation payable in money, the court may, after hearing, determine the amount to and order the distributes to contribute to its payment.
The court may issue execution against the bond, the real property belonging to the deceased, or both.
The bond and the real property remain charged with liability for the full 2-year period notwithstanding transfers of the real property. Thus, the settlement and subsequent transfer of property do not automatically extinguish the rights of creditors, heirs, or other persons protected by Section 4. However, the 2-year rule must be read together with Section 1.
An extrajudicial settlement is expressly not binding upon a person who neither participated in nor had notice of it.
Therefore, the 2-year limitation cannot simply be invoked against an omitted heir who was never bound by the settlement in the first place. Bar question: 2 years after an estate was settled and distributed under Rule 74, a creditor discovers that the decedent left an unpaid debt. The creditor seeks payment from the estate. Is the creditor automatically barred because more than 2 years have passed?
Answer: generally, the special remedy under Section 4 is subject to the 2-year period.
Section 4 provides that within 2 years after settlement and distribution, unpaid debts and lawful participation wrongfully withheld may be brought before the court, which may determine the amount to and order the distributes to contribute. The bond and the real property of the deceased remain charged with liability during that 2-year period. However, the specific rights of an omitted person must also be considered together with Section 1, particularly whether that person participated in or had notice of the settlement.
Thus, the 2-year period is a critical limitation under Section 4, but it should not be mechanically applied to a person who was never bound by the settlement under Section 1.
Section 5. Claim of minor or incapacitated person. Period for claim of minor or incapacitated person. If on the date of the expiration of the period of 2 years prescribed in the preceding section the person authorized to file a claim is a minor or mentally incapacitated, or is in prison or outside the Philippines, he may present his claim within 1 year after such disability is removed. Section 5 provides an exception to the 2-year period in Section 4.
If, on the date the 2-year period expires, the person entitled to file the claim is a minor, mentally incapacitated, imprisoned, or outside the Philippines, the person may present the claim within 1 year after the disability is removed.
The important bar point is that the disability must exist at the time the 2-year period expires, and the 1-year period begins only after the disability is removed. Bar question: an heir was a minor when the estate was distributed. The 2-year period under Section 4 expired while the heir was still a minor. The heir reached majority 3 months later and filed a claim 6 months after reaching majority. Is the claim timely? Answer: yes. Section 5 of Rule 74 provides that if, on the date of expiration of the 2-year period, the person authorized to file the claim is a minor, mentally incapacitated, imprisoned, or outside the Philippines, the person may present the claim within 1 year after the disability is removed. Since the heir was still a minor when the 2-year period expired, the statutory disability existed at the critical time. The heir then had 1 year from reaching majority to file the claim.
Therefore, a claim filed 6 months after reaching majority is timely under Section 5.
Cases 1. Portugal v. Portugal Beltran. A decedent died intestate and was survived by his spouse and several other heirs. Believing that she was the only heir, the surviving spouse executed an affidavit of self-adjudication and adjudicated the entire estate to herself. The other heirs later questioned the transaction. Is the affidavit of self-adjudication valid?
No.
Under Section 1 of Rule 74, an affidavit of self-adjudication may be executed only when there is only one heir. The law expressly allows the sole heir to adjudicate the entire estate to himself or herself through an affidavit. Since the decedent was survived by other heirs, the surviving spouse was not the sole heir and therefore had no authority to adjudicate the entire estate to herself. Accordingly, the proper remedy was an extrajudicial settlement participated in by all the heirs or, if the requirements for extrajudicial settlement were absent, a judicial settlement of the estate.
Therefore, the affidavit of self-adjudication was invalid insofar as it adjudicated the shares belonging to the other heirs. 2.
In the matter of the intestate estate of Delgado. A decedent died intestate without children but was survived by her husband and her brothers and sisters. The husband executed an affidavit of self-adjudication claiming the entire estate on the ground that he was the surviving spouse. The decedent's siblings opposed the affidavit. May the surviving spouse validly adjudicate the entire estate to himself?
No.
Section 1 of Rule 74 permits self-adjudication only when the decedent left one and only one heir. The fact that the surviving spouse is an heir does not make him the sole heir when other persons are legally entitled to inherit. Since the decedent was also survived by her siblings, the husband could not validly adjudicate the entire estate to himself through an affidavit of self-adjudication.
Therefore, the affidavit cannot bind the other heirs, and the estate must be settled through the proper proceeding involving all persons legally entitled to inherit. 3.
VDA. The Reyes v. Court of Appeals. Several heirs orally agreed to divide the estate among themselves without executing a formal public instrument of extrajudicial settlement. One heir later argued that the partition was invalid because Section 1 of Rule 74 requires a public instrument. Is the oral partition necessarily void?
No.
Section 1 provides that heirs may divide the estate by means of a public instrument, but the requirement of a public instrument is primarily intended to facilitate registration and protect creditors and third persons. The absence of such instrument does not necessarily invalidate an otherwise valid partition among the heirs themselves.
Therefore, an oral partition may be valid between the heirs, although the parties may still be required to comply with the formal requirements for purposes of registration and protection of creditors and third persons. 4.
Hernandez v. Andal. Heirs agreed to settle and divide the estate but failed to register their extrajudicial settlement with the Register of Deeds. One heir later argued that the settlement was void because it was not registered. Is the settlement invalid solely because of non-registration?
No.
Section 1 of Rule 74 contemplates the filing of the public instrument with the Register of Deeds, but registration primarily serves the purpose of giving notice and protecting creditors and third persons. Failure to register does not necessarily invalidate the settlement as between the heirs themselves when their agreement is otherwise valid.
Therefore, non-registration alone does not make the partition void between the heirs, although it may affect its enforceability against creditors and third persons. 5.
Sampillo v. Court of Appeals. Several heirs executed an extrajudicial settlement and caused it to be published in a newspaper once a week for 3 consecutive weeks. Another heir neither participated in nor had notice of the settlement. The participating heirs argue that publication constitutes constructive notice and therefore bars the omitted heir from asserting his hereditary rights. Is the argument correct?
No. Section 1 of Rule 74 expressly provides that no extrajudicial settlement shall be binding upon any person who has not participated therein or had no notice thereof.
Although publication is required, it does not automatically bind an heir who neither participated in nor had notice of the settlement. The purpose of publication is primarily to protect creditors and other interested persons, and it does not cure the exclusion of an heir who was not a party to the settlement.
Therefore, the omitted heir is not bound by the settlement merely because it was published and may still assert his or her hereditary rights. 6.
Natcher v. Court of Appeals. An heir who had been excluded from an extrajudicial settlement questioned the settlement more than 2 years after it was executed. The participating heirs invoked Section 4 of Rule 74 and argued that the action was already barred by the 2-year period. Is the action necessarily barred?
No.
Section 4 imposes a 2-year period for claims arising after settlement and distribution, but Section 1 expressly provides that an extrajudicial settlement does not bind a person who did not participate in or have notice of it. Thus, the 2-year limitation cannot automatically be invoked against an omitted heir who was never bound by the settlement.
Therefore, if the heir neither participated in nor had notice of the settlement, the 2-year period under Rule 74 does not by itself bar the heir from asserting the appropriate hereditary rights. 7.
Neri v. Heirs of Haji Yusuf Oy. An intestate estate was extrajudicially settled by only some of the heirs. 2 compulsory heirs were completely excluded, while minor heirs were represented by their father without the required judicial authority. The participating heirs subsequently sold the property to third persons. Years later, the excluded heirs sought to recover their shares, and the buyers invoked the 2-year limitation under Rule 74. Decide.
The excluded heirs are not bound by the extrajudicial settlement, and the 2-year period does not automatically bar their claims.
Section 1 of Rule 74 requires the participation of all heirs who are entitled to participate, and it expressly provides that an extrajudicial settlement does not bind a person who did not participate in or have notice of it. Since the excluded heirs did not participate in the settlement, they cannot be deprived of their hereditary rights merely by the passage of 2 years. Moreover, a co-heir can transfer only whatever hereditary rights he actually possesses and cannot transfer the shares belonging to other heirs, consistent with the principle nemo dat quod non habet.
Therefore, the sale is effective only to the extent of the shares validly owned and transferred by the participating heirs, while the omitted heirs may assert their rights over their own hereditary shares through the proper action. 8.
Bautista v. Bautista. 4 heirs executed an extrajudicial partition excluding 1 compulsory heir. The participating heirs subsequently sold the property to third persons. 15 years later, the excluded heir filed an action questioning the validity of the partition. The buyers argued that the action had prescribed because more than 2 years had elapsed. Should the action be dismissed?
No.
Section 1 of Rule 74 provides that an extrajudicial settlement does not bind a person who did not participate in or have notice of it. The excluded compulsory heir therefore cannot be treated as though he had validly agreed to the settlement. Where the instrument is void or inexistent as to the excluded heir, the action for declaration of inexistence or nullity is generally not barred by prescription under Article 1410 of the Civil Code.
Therefore, the mere lapse of 15 years does not validate a void partition or extinguish the omitted heir's right to challenge the transaction. 9.
Macababad, Jr. v. Mazarag. Several heirs discovered that their signatures had been forged in an extrajudicial settlement with sale. The property was subsequently registered and certificates of title were issued in favor of buyers. 15 years later, the excluded heirs filed an action seeking declaration of nullity and reconveyance. The buyers argue that the action is already prescribed because the titles were issued more than 10 years earlier. Is the action barred?
No, insofar as the principal action seeks to declare the forged instrument void.
A forged deed is void because there was no genuine consent from the persons whose signatures were falsified. Registration and issuance of a certificate of title cannot validate a void instrument or create rights that did not exist in the transfer. Under Article 1410 of the Civil Code, an action for declaration of inexistence of a void contract does not prescribe.
Therefore, the issuance of titles does not cure the forgery, and the action seeking declaration of nullity remains imprescriptible. 10.
Rielo v. San Jose. Several heirs executed an extrajudicial settlement excluding compulsory heirs who neither participated in nor knew about the settlement. The settlement was subsequently published in a newspaper. When the omitted heirs later discovered the transaction, they questioned its validity. The participating heirs argue that publication barred the omitted heirs from challenging the settlement. Is the argument correct?
No.
Section 1 of Rule 74 expressly states that an extrajudicial settlement does not bind a person who has not participated in or had no notice thereof. Publication does not substitute for participation or actual notice of an omitted heir, particularly where the settlement affects that heir's hereditary rights.
Therefore, the omitted heirs are not bound merely because the settlement was published and may still seek the appropriate remedy to protect their hereditary shares. 11.
Philippine Savings Bank v. Vargas. The heirs argue that because they complied with the publication requirement under Rule 74, an omitted heir can no longer challenge the extrajudicial settlement. Is the argument correct?
No.
Publication under Section 1 is principally intended to provide notice and protect creditors and other persons who may have lawful claims against the estate. The rule expressly provides that an extrajudicial settlement does not bind a person who did not participate in it or had no notice thereof. Thus, publication cannot be used as a means of defeating the hereditary rights of an heir who was excluded and had no notice of the settlement.
Therefore, the omitted heir may still assert the appropriate hereditary rights despite the publication of the settlement.